Hello and welcome. Thank you for stopping by. In this short video, I'd like to clarify a few things that people seem to be consistently getting wrong about the rights we have here in the UK, particularly in the context of protests and the general COVID legislation. Now, this isn't an exploration particularly of common law versus statutory law or maritime law, but it is a quick look at the idea of opting out and removing your consent. So it's far from my intention to justify or laud these hideous facts that I'm about to impart, merely to point them out so that we can understand the weight of the shackles we're held under, and that in the future we might find more effective routes to stand up for our freedoms and fight the injustices we all face. I'm not a legal professional, so please don't simply take my word for it. All the material will be referenced in the description, so you can look into it for yourself and form your own conclusions. The first point I'd like to raise is the idea that because we are policed and governed by consent, that we can simply withdraw our individual consent and therefore exert our freedoms. As you can see from the screen, Sir Robert Peel's original Principles of Law Enforcement, written in 1829, not necessarily by Robert Peel himself, but they've been attributed to him, centre around the fact that public approval and cooperation, voluntary cooperation, are the basis on which policing should take place. Particularly important, point 7, the police are the public and the public are the police. The police are only members of the public who are paid to give full-time attention to duties which are incumbent on every citizen in the intent of community welfare. So the original intention was definitely policing by consent. But policing by consent, or common consent, as it's understood, is a bit of a nebulous concept. It implies that the majority of the population agrees with the principle and the action. The nature of common consent argument means that it's epistemologically nigh on impossible to pin down. There is, for example, no set percentage of a given population that is required to reach common consent, and inversely, therefore, no specific level at which common consent can legitimately claim to no longer stand. I mean, the idea that the majority of a given group believe in something, it is therefore true, is logically farcical. If 10 people are given a maths problem and 9 arrive at one answer and one of them finds a different result, does that mean even if the odd one out has used the correct methodology and the 9 haven't, that the individual should be forced to accept the wrong answer as it's been reached by common consent? No, that's quite patently ludicrous. And the position in law can be seen clearly as stated in the response to a Freedom of Information request that was made in 2012 to the Home Office. They categorically stated that no individual can withdraw their consent. And this Freedom of Information reply is still on the government website for all to see. So the current trend of resisting by stating that one does not consent is valid and commendable in principle, but it doesn't seem to be a tenable legal argument and provides no protection for the individual or the business concerned. The next issue concerns what we refer to as our rights, particularly in this context, our rights to freedom of expression and our rights to freedom of assembly. Whilst these rights are enshrined in the European Convention of Human Rights, Section 10 and 11, and ratified in the UK Human Rights Act 1998, they are in fact not absolute rights. Under the law, they are qualified rights. This in effect means that they're subject to amendment or effective withdrawal by the use of any lawful instruments, for example Public Order Acts, and the more recent slew of Public Health and Coronavirus Acts. Just as an aside, the right to freedom of thought, yep, that's a real one too, as protected by Article 9 of the European Convention on Human Rights, is absolute until you attempt to actually express or convey those thoughts. And then you move into the territory of Articles 10 and 11, which are qualified rights. Thank you very much, Mr. Orwell. All that being said, the final issue I'd like to raise is the simple fact that police constables are individually and personally responsible for their actions at all times, and that includes when policing the protests. The "I'm just following orders" type of defence does not hold up. Yes, the chief constables can also be held responsible for the actions of the constables in their jurisdiction, or under their jurisdiction, but each police officer ultimately acts as an independent entity within the law. All of their powers derive from the oath they take to affirm the office of constable, as the College of Policing point out in their ethics document. It also states in this document that the police constables cannot be ordered to make arrests, which is curious because it would seem contrary to the enforcement actions that we've seen at this year's largely peaceful protests. As for the tactics and supporting laws that encompass the policing of protests, it may be important to be aware that on October the 5th, 2020, the Home Office initiated an investigation into the way that this is conducted and whether legislation changes or new legislation is required to ensure that the state's aims are met. See point 5. Also note that every force in the UK is included in this review. That's it for now. It was brief and to the point, although in researching this topic I've come across lots of interesting threads which I may well unravel in future reports. Thank you for watching, stay informed and keep resisting the tyranny where you're able to.